This is a public hearing for the abandonment and recreation of Fern Avenue. All property owners have gotten a notice. For many of you here, this is actually the second hearing that we've had on this subject. And the last one that was held in the end of June, I believe it was. End of June, 1st of July. There was a request to have Brian Brown from the Wapak County Zoning Department come in and explain some of the impacts on the zoning ordinance and things like impervious surface calculations and land divisions. So he is here this evening. I've got a couple things. We're now technologically advanced here in the town of Dayton. Pretty soon I'll even have be able to text message or receive text messages, but that's coming. So the Fern Avenue was originally platted as the P. Comio Park plat in 1903. In the early 1900s, the roads were built by the towns through the Wapak County Highway Department for new subdivisions. Basically, all you had to do was request a road, and they would come in with a bulldozer and throw some gravel, and you had a road. Oftentimes, though, we found that rocks, wetlands, or some type of natural formation got in the way, and the bulldozer operator simply went around the obstacles, and the roads were carved into the easiest place. The property owners got a benefit from that. The road construction and road maintenance subsequent to that. The current law requires that a survey and a completed road, which means a blacktop road, be completed before the road is accepted by the town. So that's what the original plat map looked like. It was a very large document, and it was folded in four, and it's a 100-year-old piece of paper. The lots were created in two places, on Marl Lake and along Long Lake, out of one large, what they used to call government lot. The area along Marl Lake was then replatted in the early, around 1910, I believe it was. And Whispering Pines Road was created in its current location. The lots come out, especially on the north end, from that plat. If you go down Whispering Pines Road near Marl Lake, you can still kind of see where that old roadway was, because there was a row of garages that were built in that next to that old roadway. And this is the surveyors. Let me just see if this works. That's where the surveyor basically went through and said he followed the statutes of that time, which I think were 19. No, it was 18. It was an 1800s state statute governing how surveyors surveyed lots. At the top, you see Pleasant Valley Street. Pleasant Valley Street was basically an extension of what we currently call West Road. That was called Pleasant Valley Road prior to the creation of Hartman Creek State Park. And this is the north end of P. Comio Park. part of what we are looking to do is correct this portion here. Because this road was platted to the water's edge, even though a bridge was never created up in this area, because the road was platted to the water's edge, that is a public access, according to the state of Wisconsin. So we are working on correcting that with the property owners in that area. But if you look here, most properties or current surveys require monuments at the property corners, and this survey did not monument the property corners. It looks like in the center of this lot there was a stake in this area, and then I think a few lots down I thought there was possibly a stake over here. But after 100 years, many of these corners can't be found, and they didn't reference the standard surveyor's marks, which went from section corners in this plat. For some reason, this takes a long line to load here, but we should get the south part of Fern Avenue, which doesn't seem to be coming up. I'll pull that up separately, but the plat stopped at the section line, and in the original plat there was no connection of a road shown to what is now rural road. At a later time, there were four, actually that's 3 additional lots were created south of that section line along Long Lake, and there's no town record of the road south of that section line at all. So the original platted location was in the lowlands adjacent to what is now called Fern Avenue and the lake lots. I suspect that they couldn't bring a bulldozer in and create a road where that road was platted at all. So in 1910, the town board received a petition from the original lot owners asking the town to relocate the road. And I guess the pertinent information is said road to be relocated to a more convenient place due to the impossibility of improving the same as shown on the recorded plat. It is understood that the town board will relocate same, staying as close to the west end of the lots as possible and using discretion in laying same so as not to damage property very materially. So that's how Fern Avenue ended up where it is right now. And I guess of substance, this statement also doesn't include a roadway width. So this is overlay of the current roadway, and let me try this again here. This line here is what the Wapak County GIS department estimates as the location of the platted road. And if you go out there, it basically follows the bottom of the highlands. This is the current location of Fern Avenue. This isn't quite accurate because took a aerial photo and did some estimations. This part here is where the Durnings have their driveway. The turnaround at the end of Fern Avenue is right in this area right here. These are the 3 lots that were created after the platted map. And this is what a survey looks like. This is not a certified survey because the surveyor, amongst other things, had questions about the roadway and the platted map. That precipitated his request for clarification from Wapak County Zoning Department, I believe, and Ryan Brown contacted me and told me that there was an apparent issue here because the platted road was not where the actual roadway was. In some cases here, the platted road is estimated to be 37, 52, 45, 36 feet. And I believe those measurements are from the center of the existing roadway. I think they would be 37 feet from the center of the roadway to where the surveyor estimated as the edge of the platted road. And I say estimated in this case because the plat says that each lot was 50 feet wide, but the measurements they show as from the water's edge. And we don't know if that was a high water mark or a low water mark. And I know it's never happened on Fern Avenue, but there have been places in the town of Dayton where people have brought fill in over the last 100 years. And the water's edge 100 years ago is no longer where the water's edge is right now. And because there was a lack of surveyors' benchmarks, we don't really know how far the original platted road was from the lake, from the current lake. And when surveyors do their survey, they use the best information that's available to them, and that's what they certify. So we have a couple of statutes that are pertinent, and the biggest question is this a laid out road or a platted road or a unrecorded road? And it's my belief, and actually I've got an attorney's letter here that I think I'll probably read for the record. That it's a unrecorded road. So because when roads were laid out, the dimensions of the road were part of the record, and roads were laid out generally 100 years ago as a 4-rod road, which is in more current terminology a 66-foot wide right of way. There were some roads that were laid out as 3-rod roads. And that would equate to a 49.5-foot right-of-way. In the town of Dayton, we have right-of-ways for roads that are anywhere from 16 feet to 66 feet. So, and there's probably almost every combination in between. So a recorded road is a recorded highway that has been laid out and has been opened and worked for 3 years. The original road was a platted road. It was not a laid out road. Any laid out highway that has not been fully or sufficiently described for the records, is presumed to be 66 feet wide. For an unrecorded road, any unrecorded highway that has been worked as a public highway for 10 years or more is a public highway and is presumed to be 66 feet wide. And then in part of the statutes on subdivisions, which is what a platted road is, that lands intended for streets, alleys, ways, commons, or other public uses as designated on said plat shall be held by the town, city, or village in which such plat is situated in trust and for such uses and purposes. So that describes what the original platted road of Fern Avenue was. It's still held by the town, even though it was never developed as a roadway. So that's part of our action now, is to abandon that original platted road, to become abandon it to an adjoining property owner, because the town does not intend to develop that road basically at the top of the swamp. And where there's an access, there's a requirement that accesses be at certain intervals, and that eliminating a public access has to be approved by the Department of Natural Resources. And we have been in touch with the Department of Natural Resources about substituting the access at the end of Fern Avenue for one that would go directly to Emmons Creek. And of note here is the last paragraph, that this subsection does not require any local unit of government to improve the land provided for public access. And for the record, I will say that the town of Dayton has no intention of improving any public access off of Fern Avenue. So that leaves us a couple options, and I would like the people that wish to contribute here tonight to speak to one of these options. The options are to divide the old platted road down the middle and assign half of it to the property to the east and half of it to the property to the west. That's what is normally done in most cases where roads are abandoned. This is a special case where we don't have a good indication of exactly where that original platted road is. So it would be hard for the town to determine which half goes, or where that center line is of that platted road, to attach it to either property. And that would be option C. There's still a problem there, is that we may be creating a orphan, or I'm sorry, yeah. The other would be to attach it to the lake property, and that may create a separate orphan parcel separated from the lakefront property by a public roadway. And Ryan can maybe speak a little bit more about the problems that creates. The other option, and this is the one that I originally recommended, was to attach it to the successor to Outlot C, which would be the property west of the platted road, or for more better terminology, the swampy lots that are along Fern Avenue. That would not create any orphan parcels, and the swamp area was originally created as one large outlot in the plat, and it was subsequently, in later years, divided up. Most of it was attached to or purchased by or somehow transaction, but most of those lots now are owned by one or more parties that also own the lakefront lots. And this I think I already covered. The DNR approval is required to abandon an access now. And that's a more current picture of where the existing public access is. Now the other question that has come up is the width of the roadway. And to be honest with you, I was hoping that the town would not have to address that. And in the original notice of the public hearing, I did not have a roadway width specified in our request to abandon and create Fern Avenue as an unrecorded road. Unfortunately, as Ryan told me, that doesn't solve our issues for parcel size or for land divisions or for impervious surface calculations. All of those issues remain if the town doesn't declare basically a road right-of-way. I received this email today from an attorney from Madison, Dean Richards, and is there any objection to me reading the letter into the record? I write on behalf of Karen Ellman and members of her extended family who collectively own properties in the town of Dayton located at N2246 and 62 Fern Avenue. I ask that this letter be included in the record of the August 26th public hearing for the discontinuance of the platted location of Fern Avenue. Discrepancies between platted roadways and work highways are certainly problematic for both local governments and the landowners affected by these circumstances. In this case, we're especially mindful of the consequences the town's proposed action will have on properties owned by Mrs. Ellman's family. The reality of Fern Avenue's location makes it difficult to argue against the proposed discontinuance and declaration of an unrecorded road. Instead, we ask the town board to carefully consider the expected impacts your actions will have on the measurement of lot area for the properties involved. I acknowledge that Wisconsin statutes section 8231 presumes that an unrecorded highway is 66 feet or 4 rods in width. However, this presumption is involved for a roadway not previously recorded and for which a width is not otherwise established. It does not prevent the town board from considering and establishing an alternate width. In the case of Fern Avenue, a 66-foot road right-of-way is unneeded and unjustified. The practical width of the road and the expectation of any further expansion or improvement of the road makes a 66-foot right-of-way far beyond necessary or a practical width for this road's right-of-way. We respectfully invite the town board to consider establishing the width of the road right-of-way at a substantially lower width. Essentially, we ask the town board to rebut the presumption, and I'll add in state statutes, and establish the right-of-way at a more practical width. Please note that Wisconsin statute section 8250 allows a local service road with intermittent traffic to be established with a 3-rod or 49.5-foot width. I also invite the town's consideration of Wisconsin State Statute section 8250 that authorizes the Department of Transportation to work with the town in setting even lower widths for right-of-ways. The department may approve deviations from the minimum standards in special cases where the strict application of standards is impractical and where such deviation is not contrary to the public interest and safety and intent of this section. The town has options available to it other than to blindly follow the presumption of a 66-foot right-of-way. Specifically, we urge the town to adopt a 20-foot right-of-way. This is not a situation in which a new road is being planned and future development may necessitate roadway expansion. Fern Avenue is a mature road and will not be the subject of expansion in the future. For any of a number of reasons, the roadway will exist in the future as it exists today. In the typical right-of-way scenario, the town might consider future expansion, the need for shoulders, the location and sizing of drainage ditches. But here, these considerations are unnecessary. The road has been in existence for a very long time, and the appropriate road width and ancillary improvements have been settled through the passage of time. The appropriate right-of-way should be consistent with the current road surface and little more. We ask that a right-of-way width of 20 feet be adopted by the town board. We further ask the town to go beyond the simple consideration of road width. The establishment of Fern Avenue as a new highway with a width greater than the original platted roadway would have a significant effect on the landowner's ability to divide and improve these properties. I ask the town board to consider concurrent legislation that will address the inevitable problems that will arise following the adjustment of Fern Avenue. Please consider adopting a resolution to address these issues as follows. For the purposes of calculating lot area, landowners abutting Fern Avenue will deduct from the gross lot area the lesser of the area of the originally platted Fern Avenue right-of-way, or the right-of-way as established in 2014. For purposes of calculating, that's 1. 2, for the purposes of calculating lot area, the new Fern Avenue right-of-way will not disrupt the original platted lot. The land located on both sides of Fern Avenue will be considered a part of said lot without regard for the separation caused by the new Fern Avenue right-of-way. 3, for purposes of calculating impervious surface on a lot, the lot owners will not be required to include the impervious surface area of Fern Avenue. We hope the town board can appreciate the special circumstances that exist for the landowners. Addressing these issues now will eliminate the inevitable need to address them later. Thank you for your consideration. Dean Richards. I will concede as a town chairman that everyone would like to have the minimum amount of road right-of-way and the maximum amount of property adjacent to their lots. I understand that the town board's responsibility is to consider that, but also to look at the standards set by the state and the need for a consistency across the town of Dayton, not just to one specific location or a set of property owners. I will concede that everyone here would like to speak to having the smallest possible road right-of-way. And the town board, in making their decision, will consider that, but we will also have to talk to some highway experts and probably the Department of Transportation and some attorneys. And so we certainly are not in a position to debate that today. So if you would take as a concession that we expect that everyone here would like to have the least amount of right-of-way as possible, maybe we can discuss some of the other issues also. Perhaps Ryan, would you like to address some of the questions? And
Sure. Could you put that survey
sure.
back up? One of the big use. Land division and minimum lot size is on a Group 3 lake, it's 20,000 square feet. And so the size of that road, that's why that is so important, as Chris Klein had mentioned, because the right-of-way that gets determined is going to also determine the square footage of all those lots, and whether or not any future land divisions will be available to them. When it comes to impervious surface, that's really, it basically comes down to the same thing. The impervious surface calculations is based on how much land you have and the amount of impervious surface you're allowed, 15%, but no more than 70 without mitigation. So the more right-of-way that exists means the less land you have, which means your ratio gets harder to achieve depending on how much pervious surface you have. So it's basically just a direct correlation as to the width, the size of that right-of-way. But the real big issue here is the 20,000 square feet, and that's why this even came up initially, was that we were faced with this survey and we were unable to determine whether or not it would be a legal land division because we didn't know exactly how much land was there, because technically speaking, there are 2 Fern Avenues right now. When I contacted the Department of Administration, I contacted Renee Powers at Plat Review, and she said that even though it's as silly as it may sound, there is in fact a platted road and a traveled road. So right now, the right-of-way, although it defaults to a 66, I mean, you're talking about basically the whole back end of those lots is all considered to be right-of-way right now. So that's why this came up. I contacted Chris to basically allow him the opportunity to take care of this at the town level. The state statutes does allow for counties to handle this through the county board, but this is definitely more of a local issue than we just assume, as much as Chris would probably would prefer the county go back and forth on this, but that's why essentially we're here. Is there any questions in terms of the land division or what this means in terms of planning and zoning? Or why this is necessary?
Brian, when you talk about the 66-foot width,
Yes.
that's measured from, is that 33 feet from the center line of the road, the bottom of the road?
Generally, yeah, because now again, that 66 goes back to the way it's written, is that it's just presumed to be 66. Like the statute that Chris was mentioning, that had on the screen here, is that right-of-ways, unless otherwise noted, are presumed to be 66, and generally speaking, is 33 off center line. But you can't use that as your reference point because not all pavement is actually run right down the middle of your right-of-way. In fact, it happens fairly often that the pavement could be on one side or the other. So that's why, for our setback purposes, we always say 63 feet from center or 30 from the right-of-way, whichever is greater, because it's not necessarily always consistent that they're the same number or that it comes to the same thing.
And that maybe should be a point, because that question has come up. You know, am I going to have to tear down my garage because my garage is only 30 feet away from the center of the road right now? The current setback, whether the roadway was 20 feet or 66 feet, the setback would still be 63 feet from the center of the road, because that would be the greater of the setback criteria. And that does not apply to existing structures before that law was created, but it would apply to an expansion or a change in that particular structure. So the town decision on the right-of-way should not have an impact on the setback from the center of the existing Fern Avenue. Is that correct?
Yeah, that's true. All the existing structures that are along that road would be considered legal non-conforming or grandfathered. And that is true, that no matter what, if that road becomes, if it's 20 feet or 66 feet, Yes, that is true, because our setbacks would be whichever is greater for the setbacks. Now, I mean, that's not gonna be the issue moving forward in terms of planning and zoning. The big issue is going to be land division. And impervious surface, but it's hard to really talk about impervious surface because it's such a personal, it's more of an individual thing, because the only time we really talk about impervious surface is you're gonna be putting on, let's say, a new shed, or new something or other on your property. Because impervious surface is also considered to be legal non-conforming. Our shoreline ordinance came around in 1997, so basically if you're sitting there with 35% impervious surface, that's fine. That's considered to be legal non-conforming. So the only time that's even going to come into issue is if you were to increase that for some reason. If you were to add a covered deck or something along those lines.
Okay, so on this survey, how wide is the platted road?
On that survey right there, the width is not actually specifically shown on the actual survey. I believe he put a note, if you could zoom in.
Yeah, let me expand that again here.
So basically, the surveyor here, Mark Karlofsky, what he is saying is that the initial plat, he scaled that plat out to show it to be plus or minus 20 feet, and surveys of record south and not in the plat have Fern Avenue at 25 feet in width. But he's not actually showing that, because typically what surveyors will have is a 25 one across here, but he just included that as the note on top.
But so he says at the south.
Yes.
There's documents that say it's 25.
Well, there is a survey, I believe for your property at Rural Road that references an earlier survey, and I think that's for the Olson property that is south of the plat, that mentioned a 25-foot right-of-way. In the 1940s, when the survey for the Olson property was created, surveyors sometimes showed roadway width, sometimes they showed to the edge of the road right away, and sometimes they showed to the center of the road. And we have numerous instances in the town of Dayton where, as an example, Cleghorn Road is shown as 66-foot right away. It's also shown in some places as 33 feet to the center of the road. And the survey that's referenced in 1947 does not mention the roadway width. It just says 25 feet of right-of-way. So there's no indication in that survey that that was to the center of the road or the entire roadway, and there's no record in the town of Dayton records that a 25-foot road was accepted by the town going from the this plat here out to Rural Road. So
What about with the conservation easement? There's nothing in there about the roadway?
well, there's nothing in the town records indicating that that's the accepted road. That there is an accepted road and that there's a specific road width for Fern Avenue. Yes, ma'am.
Can we go back to the platted road? Now, you're talking about abandoning the platted road,
Yes.
and the width of the platted road is,
The width of the platted road was not described in the original plat,
well,
and it was not benchmarked in the original plat.
I thought there was a note on it, though, that original plat, there's a note saying that it was to scale, and that it gives you the scale.
Well, when you're dealing with a 100-year-old hand-drawn parchment,
Right. Can you go back to that?
then there's no measurements on.
Well, there are measurements from the water's edge to the platted road on that document.
Right, but not for the road.
No,
And the
but
question
it-
was the road.
But it does talk about scale. On the original plat, if you can pull that up,
I don't know.
the next, where he signed that page, there. Yeah, it talks about scale, and it talks about how wide those lots are as being 50 feet,
Yes.
and then it gives you the scale of the map. So if you take that, you can figure out the scale of the platted road.
And that's what the surveyor, Mark Kolowski, said, it's approximately 20 feet. And I don't think anyone is denying that that was the approximate scale of the original platted road, but that's not where the road was built.
No, I understand that. I was just trying to get a sense of the size of the platted road, or agreement on the size of the platted road. So you're talking now about if we go back to what you're gonna do with that 20 feet, and you're proposing just to have it go to the people that own swampland,
Yes.
as opposed, so if you go back to our survey though, that would impact our property.
The roadway was platted 100 years ago, and it was platted at the bottom of the hill in the swampland, apparently for some purpose. That was the area that the original road was created from. I don't know, there's nothing in the record that says, what the intentions were 100 years ago that would lead us in one direction or the other. Now, and I don't know if it's possible to add it to the properties on the lake side of Fern Avenue for the benefit of the lake property owners when it's still separated by Fern Avenue and the right-of-way of Fern Avenue.
Could we go back to the survey then?
Sure.
So,
This location here is 27 feet from the center of the road to what the surveyor feels is the original platted road. If a right-of-way is 66 feet, it's going to extend beyond, the right-of-way would extend beyond this point. To create a parcel over here to attach to this lot here, I don't really know if that's justifiable.
well, but that's the question. Why do you need 66 feet? Why not make it a 20-foot road instead of 66? I don't see the need for a 66-foot right-of-way.
Well, all of you are familiar with the road work that has been done on Fern Avenue, and the town maintenance extends beyond the blacktop portion of the road. We push snow out of the way, we place signs outside the blacktop, we do improvements for safety outside of the actual blacktop. And I can tell you that I would not be in favor of a 20-foot road under any circumstances in the town of Dayton.
Well, right now, the paved portion of the road is 13 feet by our property.
Mm-hmm.
So I guess I'm not understanding the need to expand that. If you're saying it needs to be 66 feet, you're going to be down in the swamp, or you're going to be up in the hill.
And that is the standard for a roadway, because roads have drainage issues that have to be maintained. There are safety issues that have to be addressed. So the town's responsibilities extend beyond the blacktop in every single road in the town of Dayton, and I would guess probably in the state of Wisconsin.
But you have discretion in what you do. I understand you're saying that there's a statute that says 66 feet, but there are also statutes that say that you have discretion in what you do. And depending on, and if you go back to what you say was the request, it actually was a permission granted by the landowners, and there's a whole sense of Fern Avenue as being special, even though I understand that it's inconvenient for the town to have it be special. There's a sense of beauty there that could be very easily destroyed if we don't try to protect it.
Well, that was the request that your attorney sent us. I read the entire letter for the record, and at this point, I can't tell you that a 20-foot road, even if it was decided to be in the public interest, is possible. And adding property to an adjoining property owner would be difficult to justify as being in the public interest. The public interest is all of the people of the state of Wisconsin, all of the people of the town of Dayton, not just the adjoining property owners. And that's what we have to look at. And again, we will have advice from the Department of Transportation. We'll have advice from attorneys, and for the record, I don't believe that a 20-foot road right away can be justified in the town of Dayton under any circumstances. If you have information that it would be in the public interest, or your attorney has information that it would be in the public interest to create a special exception for Fern Avenue, please feel free to share it with us. It'll be sometime before this goes to a town board resolution. We will have some reviews by attorneys from the Department of Transportation if necessary, probably the zoning department and the county highway department. And I would say it will be at least 60 days before I draft a resolution. Once I draft it, I'm going to send it to the DNR because they will have to approve a substitution of access one way or the other, and before the town board takes a final action on that, we will get a recommendation from the DNR. So this will not be an overnight process. It will not be a September 1st process, but that's the purpose of having a public hearing at this time of the year, so the people that are not year-round residents to this area have the opportunity to chime in. So is there anyone else that would like to add something?
I'd like to ask a question of Ryan. How many other townships have roads that are not platted where they're, roads where they are not platted where they, or Fern Avenue situation?
Not recorded.
Not recorded.
Oh, I presume it exists fairly often, but we don't typically, they don't go through our office because that's dealt with more of the local issue. In fact, I'm dealing with one right now in the town of Bear Creek. It's a different situation. It's more of a stubbed out quarter-mile long road that nobody really wants, and no one really knows why it's even there. That's more of a likely scenario. But this definitely does happen. When they platted this road, it was quite obvious that they didn't walk the path before they platted it, because you're not going to build this road in a
audience is, if, let's say we do a 4 or 3 rod right away, or 3 rod width, 49 and a half feet. And the property to the left or west of the current established road, between that and the platted road, can that property be added to the property on the other side of the existing road and be used in their tabulation for impervious and or splitting?
Total square footage?
Yeah.
No, what we have an Attorney General's opinion, that we just recently codified in our ordinance that says that any public right-of-way that goes through somebody's property already effectively divides the property into 2 parcels. So now they may be one tax parcel, but they're going to be 2 separately conveyable physical parcels. So that property that's going to be lying on the west side of the traveled plat of Fern Avenue is being largely unusable. I would venture to guess it's largely unusable as it stands right now. I just drove down that road right before this meeting, just taking a look at it, and it really is largely unusable. We're not going to be able to use that square footage on that side for the purposes of land division on the other side, because they're considered to be separately conveyable parcels, even though they are technically substandard lots because they don't meet minimum lot size.
And someone that owned land on both sides of the road now, which there are a number of landowners in that area that do, could not split a 20,000 square foot lot on one side of Fern Avenue because they also own another 10,000 square feet on the other side of the road, and they want to add that to the lakefront lot to create a 20,000 square foot lot.
Right.
So regardless of whether the town attaches the old platted Fern Avenue to the swamp lots or to the lake lots will not make a difference.
For land division? No.
For land divisions, it will not make a difference for setbacks, and it will not make a difference for impervious surface calculations.
No, the only real germane issue when it comes to the width of that right-of-way for the travel is that it will definitely affect their ability to divide their property, because depending on the width as to where that right-of-way is, the right-of-way, or the square footage on the east side of that will obviously be affected. So the impervious surface calculation and land division capability will be affected depending on the size of that right-of-way. It's just that the remnant parcel is what you're specifically referring to. That's really not the germane issue. It's the land that is to the east of the travel Fern Avenue. So if that right-of-way becomes 20 feet, obviously there's going to be far more land available on the east side for the purposes of potential land division and impervious surface. If it goes to 66, obviously there's going to be 42, 21 feet less.
Yes, sir.
You had indicated that the traveled way isn't necessarily in the center of the right-of-way, as the right-of-way may be laid out. The pavement doesn't really designate where that right-of-way center line is. In this case, if you make the east part of your 66-foot and have the road on that edge and take it all the other way, then nobody loses anything, is that right? You're talking about losing anyway, but you put all of it on that side, so your 66-foot or somewhat of a smaller portion, say 5 or 6 feet, on the east side of the traveled way and go 66 feet the other way, and that road stays there and nobody loses anything in their front yard, as he's suggesting. If you take it in the middle of the pavement and go 33 feet either side, they lose 33 feet off their front yard. If you keep that pavement on the easterly edge of your 66 feet, nobody loses very much, and it solves quite a bit of a problem as far as what land usage is going to be and whether or not your square footage is going to change. Is that possible? I mean, you said that oftentimes that isn't in the middle. It could be anywhere on the 66 feet. And in this case, you could do that by just laying it
you know, as an example, my house is on a curve in the road in front of my house, and my house is in a platted subdivision where the roads are 66 feet wide. As the road comes around the curve, it is about 10 feet off center at the
You're talking the actual pavement.
actual pavement at the apex of the curve. Where the road is straight, the road is generally in the center of the right-of-way. When it comes around curves, that's more of a engineered kind of question than a surveyed question. The center of the road is an established terminology for zoning and for legal land divisions. Establishing some other kind of center of the road, I think, would require a pretty big expense for the town of Dayton, and probably mean that the entire roadway from one end to the other would have to be surveyed and a certified survey map file. That's my off-the-cuff opinion, but would you agree with that?
I guess,
If we created a road not based on the center of the road,
it would depend on, you just have to justify it. I mean, because in the end, it's gonna be, you have to justify it either way, in terms of what's necessary to maintain it. So if you feel that you can justify saying that we're only gonna have, say, 10 feet on this side and 30 feet on this side, you know, I mean, generally speaking, town roads go down the middle of the right of way. When these roads were originally platted, the idea was to try to be as fair as possible to both landowners. So that's why they tried to split right down the middle. They almost always try to travel on section lines or 40 lines and try to be as fair as possible. So they always try to be as right down the middle, because you don't typically have situations like this. Typically, you would have two landowners, one landowner here, one landowner here, and it's just a matter of who's going to win, and you know, who's going to have more of their land under right of way. So this is kind of a atypical situation when it comes to that.
Ryan, what would happen if the town, I think you mentioned a little bit that the county could do it, but if the town just opts, say, hey, the road where it's at, we're just gonna keep maintaining this road. We're not gonna do anything. Then it can fall back to your office and you would go to the county board, is that?
Through the county board.
Through the
State statute does have a provision that allows our county board to do this, basically the same process.
Okay.
And then it would be basically incumbent on us at that point then to establish the legal description for the new road, which would be, we would then determine the width based on that. But the issue though, I mean, from my initial conversation with Chris on this is that we're trying to keep this a local issue rather than have the county, you know, kind of step into a local issue, I guess, you know.
and it's a town road, it really is the town's responsibility. Is there anyone that has anything they'd like to add to the record?
I have a question.
Yeah.
So you're gonna survey this road?
No.
So,
That was not my intent.
well, how do you know where anything is? How do you
Well,
know?
again, the center of the road is fairly well established. And the center of the road is something that actually Mr. Karlowski marked between the parcels in question here.
Well, that's for these properties, 6 lots, but what about the rest of them? I mean, if you go on, if you show the whole thing, Mrs. Johnson has property that's not shown here on this survey, all the way down.
Right.
This really affects property farther down, who's next to you? Hadley, since it affects them.
You know, it affects everyone
Right,
on that road.
well,
We understand that.
Okay.
It does affect everyone on that road.
so to find the middle of the road, you just go out to the blacktop and.
The way the surveyors do is they find the blacktop, they measure from one end of the blacktop to the other end of the blacktop, and then they put a nail in the center of the road. And that's what they mark
Blacktop
as.
that's been patched numerous times.
That's a road.
Okay,
Roads get patched all the time,
well,
right? Highway 10,
changes the center of the road then, when it gets patched.
The surveyor takes the best estimate of where it is. He doesn't measure every foot of the road to see where the center is in every 1 foot section as we go up and down the road. In this particular case, he measured the center of the road at a point where each of the original lot lines were of the 6 original lake lots, and marked it there.
So when the town takes land from landowners, you pay for it?
When the town takes land from landowners, yes.
Yeah, okay.
When there is an existing roadway and there's a presumed existing right-of-way, we are not going to take land from anyone. All we're going to do is write down what the state statutes say the roadway is.
But
The
how do you
roadway
know
has
what
been
the
there.
road is?
The road has been there for 100 years, I assume. I assume it was built sometime after 1910 in that early period. It was built by the town of Dayton back around 1910 or 1912. I was not there, and I was not the town chairman at that time.
I guess I still don't understand because you're telling me you don't know where the road exactly exists.
No, I know where the road exactly exists because I've driven up and down that road 100 times myself.
and the way the zoning department uses the center of the road, they go out there, they find the center of the, correct me if I'm wrong, you find the center of the road, and that's where you measure your setbacks from.
Yeah, typically the reason why we have that is that sometimes the right of way can be really hard to determine. The vast majority of roads, the right of way isn't actually marked. Mostly, you can see it on state highways, where you'll see that RW, that yellow sign, you'll see those on the side. Some county highways will have that, but by and large, most roads are, the right of way is not marked. So we try to use the best resources, the best information we have at hand, and that is to take the pavement, the width of the pavement, take that, divide by 2, measure that, put a spot right there, and then measure over and see if that makes sense in terms of the right of way. And then we go from there in terms of how to determine setback.
So when you put this road, I mean, you say you know where this road is, this is a 13-foot wide road.
The pavement portion is, yes.
Okay, well, let's say it's 13 feet plus 4 feet on each side. So it's a, whatever that is, a 21-foot road, wide road.
The roads include the road right-of-way.
Okay.
And the road is presumed to be 66 feet wide by state statutes, whether the pavement is 10 feet wide, 20 feet wide, or 40 feet wide.
I understand that, except that in this case, or in any case, the town actually has the discretion of not making it 66 feet wide. Because it doesn't fit in this particular instance. There isn't any need for a 66-foot wide road out here. You can't go 66 feet.
Well, the town has been maintaining considerable sum of money over the last 5 or 6 years in property across from you know, your lots or your houses, and we had to go beyond the actual blacktop, you know, pavement to correct erosion issues and other things, and that is going to continue for as long as that road is there. You know, you've got steep slopes, you've got a drainage issue. We did the best that we can there, but that doesn't mean that it's solved for the next 100 years. And the town will be doing maintenance. When we plow snow in the winter, there's only one place to plow it, and that's down the hill. And that's part of the town's maintenance, is to push the snow off of the road into the road right away. It doesn't end right at the blacktop surface. It extends beyond that because there are drainage issues, there are safety issues, and the town maintenance includes plowing snow and pushing snow someplace.
So, the decisions that were made on the road and the maintenance of the road have come from the town?
Yes. It's a town road.
Would you agree that there have been errors made there?
There's more than one way to do almost anything, and the town officials did the best job that they could under the circumstances. Could there have been other decisions made at other times that would have, you know, resulted in something different? Yes, that's possible, but I don't know that there were any errors made.
You can Monday morning quarterback anything. The best wedding out there, you can always find something wrong with it the next day. We built that and maintain that road the best way we can. And yes, there may have been issues that have popped up afterwards. That happens on every road that is ever built. Have you ever driven down Highway 10? When it's 80 degrees out, the concrete explodes. And people's cars get demolished because of the concrete blowing up, cars hitting them. Does that mean that the state of Wisconsin screwed up when they built that road? Absolutely not. That is a road maintenance issue. That happens. I mean, the road is built to the specs. It's built the way the engineers tell us to build them. You know, it's not...
That road was built to spec.
It was built to, when we talk to engineers or contractors, I won't say engineers, when we talk to contractors, yeah, it's not built to any state specs. Very few town roads are 100% built to specs when they're old roads, because they didn't do it. We have learned over the last 100 years, when we accept new roads in, we have a new subdivision, Wild, off of Smith Road. No,
Wilderness Road.
Wilderness Road subdivision. When they wanted to bring this road into the town, we told them this is how the road has to be built, because this is what the latest and greatest specs are. And that was 7 years ago, 8 years ago, and they built it. I would have to look at, see what the new latest and greatest road specs are. They change yearly, every couple of years, because people are investigating, finding out what the newest and best way to build a road. Because the road has a sinkhole in it, because there's a drainage issue, doesn't mean it was built improperly. I mean,
Okay, I'm speaking to the fact that they came to blacktop it and were not aware that there was sewer under there.
I'm pretty sure they were aware, because I was chairman at the time when they're,
My husband was standing there,
well,
they came back 6 months later.
okay.
Maybe I'm sure they were aware at the point that they put it down.
Well, you know, the issue that you're talking about was that the sewer department had to put some lifts in some of the manholes, so when the road was blacktopped, that the paved surface would match up with the manholes. I don't know if that, you know, makes it a error per se, but
What I'm talking about is the fact that when they came to do the work, they were not aware.
okay,
So they didn't do the work that day.
correct. And actually, it was done the following year, I believe.
Right. But this is just speaking to the fact that you're talking about measuring from the middle of the road. And my point is, I don't know. I don't have confidence.
Well, the road is where the road is, and we know where the road is because we can go out there and see it and touch it and feel it, and we can point to it and we can establish where the center of the pavement is.
But it also changes. That center line has changed.
Okay?
Is that typical road maintenance? We
When
could survey 1 week, and a week later, the property lines change.
there are 3 unrecorded roads in the town of Dayton that I'm aware of, and that's Fern Avenue, Cemetery Road in rural, and one leg of Johannet Lane down by Stratton Lane. All of the other roadways have a record in the town records.
Okay, so this is a special situation.
But a record doesn't mean it was surveyed, correct?
Correct.
I mean,
The town does not survey roads, except under unique circumstances. When a road is platted, currently, all of those dimensions are part of the plat that is accepted. In this case, again, this was done 100 years ago. Rules were different then. We can't go back and change what was done 100 years ago. We take the best information that we have, and we try to make the best decisions we can as a town board.
Okay, so you're going to consult people, and then you said you were gonna do another resolution?
I'm going to have a resolution prepared for the town board.
Okay,
If they approve that, then I'm going to send that to the DNR, and again, because this involves a access to the public waters, and make sure that they will agree to it. And if they will agree to it, then we will proceed to have formally do a town board resolution.
okay, I'm not clear. You're doing a resolution, then the board will approve that resolution, and then you will send it to DNR?
We will have a resolution that will be a preliminary resolution, because before the roadway can be changed, we have to have approval from the DNR. So that's the procedure that they have asked us to do, is to send them a preliminary resolution. They will confirm that it meets their requirements. Then we can proceed to have a formal resolution. We send that back to the DNR, and if the DNR approves that, I believe the DNR will publish a notice, again, because we're going to propose changing a existing public access. The DNR will publish a legal notice if they get an objection, then there will be a DNR hearing on changing the public access. The DNR will not deal with a roadway width or a roadway location. They will deal with a change in a public access.
What about its impact on the wetlands?
They would be the ones that would deal with that.
Who, the DNR?
Yeah.
Well, there will be impact if it's 66 feet.
How would that be?
It's already been impacted with the riprap.
Okay.
Okay, that's a different issue, but, so you're doing the resolution. Will you publish that resolution before you vote on it? Or, I mean, how do we know what you're thinking?
Your opportunity for input is tonight.
Right.
It will be, all of our town board resolutions are posted to our town website, and I believe that many of you are subscribers or are notified about our town board agendas on our website.
Right.
And every single resolution that I have proposed since that website has been up, has been published on our website
Okay, so,
prior to the town board action.
so your preliminary resolution will be published a day maybe before your board meeting, is that what you're saying? That's generally when you put them on your minutes or your
Well,
the agenda goes on, yeah.
I generally do that early in the weekend, Friday or Saturday.
Okay,
That's my weekend project normally, and the town board meetings are Monday or Tuesday. Our town board agenda has to be finalized 24 hours prior to a meeting. It is not required that we publish the complete resolutions that the town board will act on, but again, all of the resolutions since our website has been available have been put in full on the town board website. All of our town ordinances have been posted in full before they have action. Town board motions generally are a little bit different situation, and they don't have the permanence or financial impact or impact on residents, and so motions are generally just handled administratively during the town board meeting and recorded in the town's minutes.
so it sounds to me like what you want to do, and you can correct me if I'm misunderstanding, is you want to have 66-foot roadway, so that in fact, you won't create parcels here between the platted roadway and the road and the travel roadway. Is that kind of your thinking?
My proposal that was part of the public hearing notice,
Right.
and actually, that was discussed at the other public hearing, is that my recommendation is that the old platted road be attached to what was originally Outlot C, which was the swamp area of this plat.
I thought,
And that has now been divided up into, numerous parcels and has a number of different owners, but that was my original proposal.
I thought your resolution, your proposal said, it will be divided between successor owners of Outlaw C, currently recorded as parcels so-and-so.
Right.
I see, so you're not going to give any of this land back to the original owners of the roadway?
Well, the original owners have all sold their properties, passed on, or don't exist. Outlot C was divided at some point in the future and, you know, people were given or obtained titles somehow to what was originally outlot C, which is the lowlands that are west of,
Right, but the land between the travel road and the platted road is not outlot C.
correct.
Okay, so, and the land where the travel road is actually is private, crossing private property. So you're taking the land for the travel road from the people, property owners. And you're now saying that you're going to give,
And if a permission was given by the property owners
for
all the way up and down Fern Avenue
right, for the travel roadway, but
to establish a road back in 1910, and that's what the town did, and that created a town road. And a town road is presumed to have a 66-foot right-of-way. So that was done 100 years ago. That's not going to be done by,
I don't think, I don't think the 66 feet was.
well, in the town of Dayton, we have 75 miles of roads. And almost all of the laid-out roads were laid out at 66 feet. There are
100 years ago.
150 years ago,
This one's not laid out.
this was not laid out. But your question, were the roads that were created 100 years ago 66 feet wide? And yes, they were.
I agree that 66 feet may be on the large side, but I also do not agree that 20 foot wide is the correct size either. And I think that's where I need to find some more information from our attorneys, from town road builders, the county highway department in particular. They're the ones that do a lot of our maintenance on our roads. I want to find out what their opinion of this is. And I think we keep going back to the 66 foot. Well, the biggest issue that I hear is 66 feet versus 20 feet. It's kind of like the far left and far right of anything is probably not necessarily the absolute best. Somewhere in the middle, I think, and I think our board does do a good job of investigating. And I will be out investigating and finding out what information is out there.
Where is the
He had a family emergency.
So.
His wife's husband is very ill.
Wow.
Wife's,
He's a pretty understanding guy.
wife's father is gravely ill.
Well, you know,
Quite the issue.
I understand that there's a big difference between 66 feet and 20 feet. But I also, I mean, we're on that road every day in the summer, and there's just not that much room for you to expand it. Nor is there need to. Everyone who travels that road, which are very, very few people, understands the road, knows what you do when you meet somebody, pull into somebody's driveway, you drive 20 miles an hour. Everybody who lives on it understands that. We understand what the road is. And I understand it's a special circumstance, and the town has to, I guess, have everybody look the same. But it's never going to look like the other road. It's never going to look like rural road. It doesn't need to look like rural road. All it needs to be is what it's been for 100 years, which is a little road that probably didn't even need to be paved because there aren't any year-round residents there. And it was a great little sand road, but it's paved and.
How many of you have LP out at your places? Do you have gas on that need to get filled up? Yep. Talk to the poor LP driver that runs down that road. I'm throwing out other things because I'm a firefighter. I used to be on a volunteer fire department. And I know driving a big tanker truck, God forbid, nobody ever has a fire down there. But you have a fire down there, and they have to bring a tanker truck down there. Maybe for nothing more than protecting all the neighbors' houses. Your house might be gone already, but getting down there with a tanker truck is going to be a big deal.
Well, I don't really know, I mean, you all live at one end, but the rest of us have these little tanks that we have to take in to have filled, you know, because it's, oh, we don't even have that anymore, okay.
The old roadway, we could have not,
Okay.
we couldn't have not brought a fire truck to the end of Fern Avenue. And-
By the time you got one out there, the house was down.
Okay, then let's get rid of all the fire department, because it's a whole lot cheaper to,
No, I'm not saying that, I'm just saying, I think it's,
Well, it's
We have to maintain-
okay for you to volunteer your house to burn down to the ground, but unfortunately, if the fire started, it would continue on to some of your neighbors' houses. And providing fire response is one of the safety requirements that a town of Dayton has. Providing ambulance service to our residents is one of the responsibilities that the town of Dayton has. And in my opinion, the way the roadway was 20 years ago, we could not provide ambulance and fire services to the end of Fern Avenue.
safely. They might have been able to get down there, but trying to get them back out of there, I worked on an ambulance in a very rural area, and this was 20 years ago, 25 years ago, when the ambulances were a lot smaller than they are. Like everything else, as time goes, everything gets bigger, me included. But you have to look at what the roads are being used for. You're saying that it's used for the half a dozen, 10 people on the road. You're right, that is what it's being used for. But then you have to have services delivered, whether it's you're having LP delivered down there, whether you're having a fire truck down there, an ambulance. Those are things that we as a town have to make sure that can get there. And if we can't be sure about it, we have to work on it. And that's, unfortunately, that's part of our job. And make sure that everybody is able to have protection.
Well, 20 years ago, Fern Avenue was a sand track between the pine trees. And the Durnings had regular garbage pickup. How a garbage truck made it down to the turnaround, got turned around and made it back out on a regular basis, I have no idea how they could do that. It was hard enough getting through there with a pickup truck. The garbage company did it. But almost every tree going up on Fern Avenue, including some of the trees that are still down by the Olsons, have scars on the side of them from the snowplows hitting them and trucks hitting them and cars hitting them. You know, if the town road, the town board is required to keep a road passable, and at some points in the past, Fern Avenue has not been passable, at least for garbage service, ambulance service, fire truck service, and
is it now?
I believe that we could get an ambulance up and down to the end. I believe that we could get a fire truck
You're gonna get a truck down there, it's gonna be tight getting them back out. I mean,
close enough, but to deliver water through tanker trucks, to be honest with you, they'd probably block off rural road and set their tanks up at rural road and relay the water down to the end.
still gonna have to get a truck down there.
and have one, they do not use lake water because
You can, they
they
can
would
use.
suck up mud and sand and everything else, and those pumps.
On $1 million pump, you don't wanna suck up mud. I'm just, if you want us to suck up mud, we can gladly suck up mud with our trucks, but most people don't wanna replace $1 million fire truck because they sucked up, when they can go down and fill at, they do use lake water, they have, filling stations that are assigned, set up different areas that,
Not in Waukesha.
not in the
Our
city.
fire department
Okay.
is not.
They don't have any, but
I have a question. Supposing you decide the 20-foot rule is 66 possibility, if you decide on, say, 44 feet, how soon are you gonna start building to get that extra 20 foot?
No, we are not changing the road, we are not rebuilding the road. We are not going to post signs up and down the road that is now a 55-mile-an-hour road because there's a 66-foot road right-of-way, which is one of the things that I've heard.
So it's all gonna be Escalante, like you said earlier, and it won't affect the road as it is.
no, now, if we run into a situation where we have a sinkhole that happens on the road, whatever the cause of it, we wanna make sure we have room to fix that. I mean, I don't see that, the pavement growing.
Okay, just wanted to confirm that again.
Well, if it isn't gonna get wider, then why do you need the 66 feet?
I just said that, because if you have a sinkhole happening on one side,
But,
If,
yeah.
if, if you call me and tell me there's a washout in front of your driveway going down to the swamp, we'll come out there and we'll fix it. And that will be beyond the blacktop. We, on town roads, we work beyond the blacktop, and the public utilities put their poles and run their gas service, they run the sewer, they run the electricity and telephone through the town road right away.
Right, it is now.
And that's not on the blacktop,
No, it's about 2 feet off the blacktop, actually.
in some places, yes.
Yeah.
So, is there anything else that you'd like to add to the record?
I just want to know, so are there minutes of this meeting that will be published, or how will the other people who were unable to come be aware of the
The,
information that was exchanged?
the town clerk, Judy Seuss, will write up the minutes, and they will be available.
On the website?
Posting the minutes on the website is still a work in progress, but they will be available in the clerk's office. Official meeting minutes are available in the clerk's office. The ones that are published on the website, when they are published, are not official meeting minutes.
So if I called Judy or something, she could send me a copy, is that?
Yes.
Right.
And I would think that those would be available probably by October or the September board meeting. So they would typically be approved at our September town board meeting.
these don't have to be approved.
These are-
No,
They'd be available, I mean, this is a hearing, this is general information she's keeping. She's not keeping a record of Jim said this, Chris said this. This is a general information going on, and I'm sure in there, it's gonna be talking about 20-foot versus 66-foot, which is what I heard is the biggest issue. The next biggest one is who gets the extra property. And, that we're gonna have to look at too.
and part of the record of Judy's record will be the letter from your attorney.
Any other
else to add? Jim, anything?
No.
Otherwise, seeing no further information, I'll declare that the hearing is closed.